Professor Sahoni will introduce Commissioner Feldblum.
Thank you so much. I'm just delighted and honored to be welcoming Commissioner Feldblum here today to deliver our keynote address. Commissioner Feldblum began her service as a commissioner at the Equal Employment Opportunity Commission in April of 2010. She was confirmed for a second term by the Senate, and that term will end on July 1st, 2018. Her focus while on the Commission has been on employment, civil rights, and civil rights cases, in particular on questions concerning employment of people with disabilities, pregnancies, sexual orientation and transgender discrimination problems, and prevention of harassment. And we are so honored that she has taken the time to be with us here in North Carolina.
Great, thank you. And I've decided that I'm going to sit because you're all eating lunch, and I'm going to hopefully make this a bit more conversational. So, and I'm going to look at the time. I'm just going to make myself stop. I hope just at 20 minutes, 25, because I really want to engage and, take questions and answer. Now, in terms of both everything I'm going to say now in prepared remarks, and especially anything in response to questions, well, I am a huge fan of social media, okay? Big on Twitter. You can follow me at Feldblum. Big on Facebook posting. You can like my Facebook page. Big on LinkedIn. And I often live tweet at various things. Do not please tweet or post anything that I'm about to say, okay? Because as far as I'm concerned, I'm not going to say anything controversial, but out there in this world, you just never know how anything can be taken. So ground rules for this. So I'm also just incredibly pleased to be here. I really love my job as an EEOC commissioner and what I can do at the commission, but I also loved being a law professor and writing articles, and it's just a delight to be able to come and be part of this and sort of drink from those waters again. So really, thanks to the Duke Law Journal for having this idea of taking in proposals, which I think is a great idea, and to Mila and Bertrell and others who did that, and to the journal and the Duke professors who supported this topic. So I know we're in a different place now than when this symposium was conceived of, and I think that's affected, some of the papers. It certainly affected, I think, what I'm going to say, in that I'm not going to take you through the narrative of how EEOC came to determine that discrimination based on gender identity and sexual orientation is per se sex discrimination, and how we're going to move on from here as an agency. Okay, but part of the reason for that is that, from my perspective, the train has left the station on this issue of coverage and moved away from the agencies and onto the courts. Now, that's not to say the agencies couldn't have done more had we had a second Clinton administration, but the fact of the matter is we have 3 circuit courts of appeals right now, 7th, 11th, and 2nd, grappling with the question of whether sexual orientation discrimination is per se sex discrimination, including the 7th Circuit en banc. And they're grappling with it in a way that would have been inconceivable 5 or 6 years ago, when it was just assumed that, of course, Title VII didn't cover sexual orientation. And I'm proud of the fact that EEOC, as an administrative agency, played a role in changing that legal landscape. And in the decisions that we issued in what's called our federal sector opinions, we were able to, what I call, engage in legal correction, right? When especially this came to the public fore, when Department of Education issued its guidance on the right of transgender students to, use the restroom consistent with their gender identity, and the outrage of, you're engaging in legal overreach, making up law. And my perspective is, no, we're all engaging in legal correction. That right when Title VII passed in 1964, it should have been clear that discrimination based on sexual orientation and gender identity was discrimination that took sex into account, which should have been illegal. And instead, the EEOC, taking the lead, followed by the courts, carved out an exception for LGBT people from sex discrimination laws. And now what we're doing is correcting that, or have corrected that, at least at the EOC, and as I said, now it's up to the courts to see if they will again follow the EOC, as they did back in the early 70s. So what I want to do, so that was my brief description of what we've done. But what I want to do for this is step back and unpack the black box of the different mechanisms that EEOC uses to advance its substantive view of the law, of which the federal sector decisions that we used on the LGBT issue is one mechanism. And I actually had no knowledge of most of these mechanisms before I became a commissioner at the EOC. I was like, EOC, charges, backlog, something like that. That's like all they do. and they also issue regulations. I just finished negotiating the ADA Amendments Act of 2008. I wanted to make sure there'd be good regulations coming out of the agency, and that's why I said yes when I got literally a phone call out of the blue from the White House about did I want to be a commissioner. So I went, I did that, the ADA regulations, and then realized there was lots of other stuff I wanted to do, hence my second term. But as I learned about these mechanisms, and in particular, as I sought to resuscitate some of these mechanisms or modify some of the mechanisms, I was always conscious of what would this look like when the majority flips. Now, I didn't think it would happen so soon and during my tenure, but unlike, I think, some of the questions that have arisen of, well, but what would this be looking like when we're not in control, I feel like that was always in my head. Now, it didn't always mean that I didn't push for something. I mean, I can think of two things where I chose not to push for something that I thought conceptually made sense because I thought it'd be too dangerous when it flipped. But a few other things I pushed for, even though I knew it could be used, because I just thought it made sense in terms of the agency. So I just thought that was interesting in the morning, you know, in terms of where politics sits, at least in my head. Okay. Now, EEOC is obviously an agency that is focused, per se, on civil rights. So that's a little different from what we've heard about this morning of other agencies that seem to not be about civil rights. But again, reinforcing from this morning, I think about my colleague Robin West, who's written about how civil rights are rights that we all enjoy as members of civil society. And that obviously includes sort of anti-subordination rights, but also distributed rights. So, okay, so let's talk about EEOC and its mechanisms. So EEOC is not only a hybrid agency in the sense that there's a private right of action to implement the employment non-discrimination laws as well as agency action, but it's also very hybrid within the mechanisms in terms of both quasi-legislative and quasi-judicial mechanisms, even though, as you will hear, I'm not so sure that Congress realized initially how much power or how much influence EEOC could play in both of these ways. So, all right, so let's start with the structure of the EEOC as created by Congress. Like many commissions, EEOC is made up of 5 commissioners with set staggered terms of 5 years. A commissioner rotates off at the end of those 5 years unless he or she has been nominated for another term and confirmed. There's no holdover provision, as there is in some commissions. Commissioners are named by the president, confirmed by the Senate. No more than 3 commissioners can be from the same political party. Okay, so under the Obama administration, there could be no more than 3 Democrats, which means we had 2 Republican commissioners. Same thing under a Republican administration, there can be no more than 3 Republicans. And actually, it'll be some time, probably, it won't be till this July when one of our Democratic commissioners rotates off because her 5th term is over, that we're actually going to get a Republican majority. Okay, so see how it doesn't switch right over with the administration. There's no removal provision that says a commissioner can be removed for cause, as there is in some, you know. But from my perspective, because I'm just big on reading the statute, from my perspective, the statute says there's a set term for each commissioner and no provision that explicitly permits removal of a commissioner for any reason. I don't know, seems pretty strong to me. I don't want to call this question, but I'm just saying. Okay, so the idea is that bipartisanship is baked into the structure of the commission. But bipartisanship is a state of mind as much as a state of numbers. I believe that acting in a bipartisan manner requires a sense of obligation on the part of a commissioner to reach across the aisle and listen to a perspective that is perhaps different from one's own. And that's not easy, but I will say from the moment I came onto the commission, that seemed obvious to me, because why else would you have a bipartisan requirement in the statute? Now, I was lucky because I had a partner on the commission, a Republican commissioner, Victoria Lipnick, who came on the same time as I did, April 2010, who had the same vision of governance and commitment to bipartisanship as I had. Because you can't be bipartisan if you don't have a partner. And as she and I would often say, especially after a long day of negotiating, doing bipartisan work is really hard. It's much easier to just go in your own corners and vote yes and no. And so I've been lucky in that. Now, I do want to say, side point, but the Sunshine Act is a huge problem in terms of encouraging bipartisanship. It's a rule that says for multi-member commissions, if you have a quorum, which would be 3 commissioners, it has to be a public meeting for transparency. And of course, what has happened is we do sequential conversations, right? So which is not as effective for coming to consensus. And as Vicki Lipnick said after we'd been there 3 months, she didn't have to deal with the Sunshine Act when she was an Assistant Secretary of Labor for 7 years under the second Bush administration. She goes, clearly this is a government in the shadows act instead of a government in the sunshine, because we then voted everything electronically. No one even heard anything, any conversation. So, okay. All right, so it creates this bipartisan structure. I want to say there is significant power that the president holds that I'm struck that it's not focused on as much, which is that, you know, we get set terms, but the president then designates the chair and the vice chair. And the president can just change that designation overnight. So that's some power that the president holds over whoever is the chair at the time, if that person wants to stay being the chair. And at the EOC, the chair has a lot of power in terms of what gets circulated for a vote. The chair holds the power about what gets circulated for a vote. And all the 5 mechanisms I'm about to describe, it's all about the majority of the commission voting for something. Okay, so the first mechanism is commission decisions in the private sector. And there would be no surprise, even if anyone here was an expert on the EOC, which I do not expect from anyone in the audience, that you would not even have a clue about that, because we don't do those anymore, these commission decisions. But there's nothing that stops us structurally from doing it. And these commission decisions initially were the main vehicle by which EOC shaped Title VII law. Shaped it in terms of its progressive interpretations that courts would then follow, shaped it in terms of its non-progressive interpretations, like its exception, carve-out for LGBT folks. So, commission decisions, why do we have those? Well, no individual is permitted to bring an employment discrimination claim in court before that person comes to the EOC first. Has to come to the EOC, file a charge, EOC has to investigate to see whether the EOC believes there's reasonable cause to think the charge is true, and there's therefore reasonable cause to believe discrimination has occurred. If so, that triggers an obligation on the EOC to bring in the employer or the union being charged with discrimination and try to conciliate. Okay, so it was set up as this structure to encourage voluntary compliance. That's what it said on its face. You could also read it as creating a structure that created a buffer for employers before they could be pulled into court. People had to go through this administrative process. But that's what it was set up to be, right? An agency taking in charges, investigating, trying to conciliate, and then later on, about 8 years after 64 Act was passed, given the authority to actually bring litigation if the conciliation failed. So I don't really think that Congress thought about EEOC playing a role in the substantive development of the law. I think that's partly also why, they put in a provision that said an EEOC can issue procedural regulations to carry out the provisions of this title, right? The charge, processing, investigations, conciliations, because it all seemed so procedural in terms of what EEOC was doing. But, if you investigate a charge and you collect the facts, now you have to decide whether those facts indicate that there's reasonable cause to believe that there's been a violation. Well, you have to have a view of what the law prohibits to know whether there's a violation. So the way the EEOC developed that view and presented that view were these commission decisions that were written in a very centralized way. So the investigations would happen out in the field. The findings of the investigation would be sent up to headquarters. You can just see those piles of paper. And then there was a division of lawyers at headquarters that drafted opinions that the commission then voted on. Right? And you had the facts, and you had the law, and you had determinations. I mean, it looked like a decision. Now, the difference was it wasn't the standard of, here's a violation, and now we will order you, the employer, to do something. The EEOC wasn't given that authority. It was a decision that said, we think there's reasonable cause to believe discrimination may have occurred. So, for example, a lot of the elements of Title VII law came out in those commission decisions first. I remember reading one where the commission did a disparate impact analysis in race because of the use of criminal background screening. In the late 60s, right? Decisions where the commission said, if you discriminate against married women and not married men, that's a form of sex discrimination. Hugely radical thought at the time. Okay, so these commission decisions, they were all anonymous because by statute we can't talk about even that a charge has been filed, much less what's in it. So that just said charging party, respondent. So it was anonymous, but they were collected in books. Literally, the books of these commission decisions, the Commerce Clearinghouse, for whatever reason, published. And they were used by lawyers, cited by courts. Now, they were not binding, obviously. Courts that used them never said deference, right? But what they did is, it's like getting a good draft memo from a staff person when you're trying to figure out what you think the law should be. And then sometimes they would also say, and particularly persuasive memo because they are the agency charged with enforcing the law. All right, so like I said, a lot of progressive decisions, not progressive in terms of transgender folks and gay folks. And very early on, 1974 was the first decision the commission issued when a transgender person brought a case. EEOC says, well, that's clearly not sex discrimination. It's discrimination on this particular operation, and it tended to be a sex reassignment operation, but it has nothing to do with sex. Thank you for sharing. Because there's nothing to do with sex, and also Congress couldn't have intended this. 2 years later, 1976, same thing in terms of a gay person bringing the case, and the person said homosexuality has nothing to do with gender. I don't know what they think homosexuality is about, other than being attracted to someone of the same gender as opposed to opposite gender, but okay. So as I said, these decisions have fallen out of use. And part of it was practical. It just became impractical to be writing all these from headquarters. And so the commission changed the rule to say that the field could write these decisions. Although initially, every time they wrote, because they wrote these long decisions, they had to cite to a previous commission decision, with the number. And then that became too unwieldy. And basically, they can just now, and this is what they do, issue letters of determination. Yes cause, no cause, a little description of the facts, no legal analysis. There it is. But as again, I say structurally, there's no reason not to resuscitate those. And it was certainly something I thought about a lot over the last 7 years because, as you'll see, it's so hard to do certainly regulations, even guidance, and this allows the commission to set forth its point of view, very quickly. Of course, at the time when we talked about it, my colleague, Commissioner Lipnick, said, yeah, sounds like a good idea, but we have to be able to write dissents. And I was like, I don't really like that, because it's not as... Now I'm like, okay, if we do this, we definitely need to be allowed to write dissents, but... So I don't know if it's going to happen. But that's the first mechanism, commission decisions. Very case-specific, quasi-judicial, even though having no judicial impact in the sense of creating an obligation for someone to comply. Okay, mechanism 2 is guidance. And again, this was very interesting, I think, in how this developed. How a charge processing agency who is given the responsibility to just issue procedural regulations for that actually ends up developing documents that talk about substance. So the second mechanism, guidance. Well, so the EOC began to collect its statement of views from these various commission decisions and put them into a document. And the document was something called the Compliance Manual. And this was a handbook. It was a manual for the investigators, most of whom are not lawyers. From the beginning, most are not lawyers, most are not lawyers now. I think that's terrible. I think those of you who are thinking about jobs after law school should be thinking about being an investigator for the EOC. Even in this administration, I think that's one of the jobs where there will be continued work in a positive way. But so you needed a manual to tell these investigators what the law required so they could decide whether there was reasonable cause of discrimination occurring. So sometimes this was just a summary of what the courts had said about a particular issue if the EOC agreed with that. But if there was a conflict in the courts or the courts hadn't ruled on a particular issue, this was where EOC put forth its view of how it was going to decide investigations. So the compliance manuals got longer and longer. Lawyers on management side and plaintiff side started using the info from the manual. Courts started using it. And now, I have no idea if the first compliance manual was voted on by the commission. I should find out. But now, over time, there are chapters of the compliance manual that are updated with something called guidance, and that guidance is voted on by the commission. And then it just replaces that chapter, but is also standalone guidance. And that guidance does not go through White House review, doesn't go through interagency review, because of course, why would you send your compliance manual over for review? But of course, you know, these guidances are pretty significant. So since I've been at the commission, I was thinking, so we've issued 4 guidances: criminal background checks, pregnancy discrimination, retaliation, national origin. We have one more guidance that is out for public comment now on harassment. And those guidances not only didn't go through White House review, but they were never even made public for input before they were finalized. And that has changed. And again, this is one of the mechanisms that I pushed for modification because I thought it would be worthwhile. So they're just on our website. It's not any formal procedure, but they go on our website, 30 days for comment, and then we have heard from the stakeholders about what they think about the guidance. So that's happened now for the last 3. And that's something that I think is a positive thing to have happened now that we've switched over to a different administration, because it creates more transparency before something is finalized. Okay, third mechanism, regulations. Again, very early, commission just issued things called guidelines. Not regulations, they're just guidelines. Of course, they went out for notice and comment. They were published in the Federal Register. They're in the CFR right now. I think in terms of the deference issue, at least what I've seen in the cases, courts are always engaged with these guidelines. But if they agreed with the end result, they would describe the analysis in some detail, explain why they agreed, and then said, and by the way, we should give some deference to the agency with expertise. Or if they disagreed, they would also mention the analysis, talk about why they disagreed, and then say, and by the way, we don't have to give deference because they don't have authority to do substantive regulation. So, you know, there's a whole debate about what would happen if Chevron was reversed, as Judge Gorsuch made a strong argument for in a concurrence he wrote to his own opinion in a 10th Circuit case that I just read yesterday. How much that would really make a difference is, I think, really a subject of debate. But, so that's sort of what happened in terms of EOC regulations. So since I joined the commission in 2010, we've issued 5 regulations. 3 were required because a new law had been issued. So the ADA Amendments Act and GINA, Genetic Non-Discrimination Act, were both regulations that I worked on and worked in a significantly bipartisan way with my colleague, Vicki Lipnick, and she voted for both of those regulations. One, because of a Supreme Court decision that had invalidated something of the EEOC regulation on the Age Discrimination Employment Act. So those three were sort of required. Two regulations that were more on our own initiative. The wellness regulations, I'm not sure I'd call that our own initiative, but whatever, we put them out. But another one that was very much our own initiative, because it's something I pushed very hard, Section 501 of the Rehabilitation Act of 1973 says the federal government shall engage in affirmative action to employ people with disabilities. We'd only had one paragraph as to what that meant, and yes, we got the final regulation issued on like January 6th or something, which gives a lot more detail about what federal agencies have to do. But all of these EEOC's regulations do have to go through White House review. Our regulations do have to go through OIRA, which is the office in OMB that does review, and I will tell you, it's not always a fun process, and it's certainly a long process. Okay, Mechanism 3, regulations. Mechanism 4, litigation and amicus briefs. So this is very interesting. I think one of the other reasons why commission decisions fell out of use is that once EEOC got litigation authority in 1972 and we started to bring cases, I think the agency used the arguments it was making in those cases as its vehicle for putting forth its substantive views and in individual cases, because that's the whole utility of a decision in a particular case, right? It can be case-specific, nuance to that. Okay, so EEOC gets litigation authority in 1972, creates a position of the general counsel, who is also named by the president, confirmed by the Senate for a set term of 4 years as opposed to 5. For years, the commission voted on every case before it got filed, because the general counsel brings litigation on behalf of the commission, so the commission would vote. And in 1995, under Democratic leadership, the commission voted for a significant power shift. And the commission delegated authority to the general counsel and then down to the regional attorneys to decide what cases to initiate, subject to some exceptions, like a case in which the commission has not opined and it's a new issue of law. And different general counsels have applied this in different ways, but there are greatest majority of cases EEOC files, we as a commission do not vote to authorize. So that's power that's delegated to the general counsel. It's also why the general counsel's position is so important. And we have an acting general counsel now. Our Democratic general counsel, David Lopez, left prior to his term, I think expecting to allow the Clinton administration to appoint a new general counsel. So now we are waiting to see who will be named by this administration, and it's a hugely, hugely important appointment. I will say that there's a lot of, I would say from the Republican side, a lot of opposition to the delegation. But when we issued a new strategic enforcement plan in 2012, that was the first time an enforcement plan had been updated by the commission since 1996. In that enforcement plan, we reaffirmed delegation to the general counsel, because for me, it would just be deadlock, right? Or just grid, not grid. I always forget that word. It's just, it'll take more time even if you end up voting yes. And create situations when you might not vote yes. And there's a term for that. So we reaffirmed the delegation. See what happens in terms of going forward. But amicus briefs is the other part in terms of litigation. And interesting, in terms of the delegation, the authority to file amicus briefs was not delegated to the general counsel. So every amicus brief that we file has to come up to the commission for a vote. And I think the idea being, if we're already intervening in a case with an amicus brief, it's because it's some significant issue of law, and we want the commission to vote. Finally, the last mechanism, and then I will close for questions, is a mechanism that was really not used by the commission much at all. And it's something that really got revitalized during my time at the commission. And these are decisions that are issued in the federal sector. That is, complaints of discrimination brought by federal employees and applicants for federal employment. You know, there was a lot of controversy over my nomination because I was not only the first out lesbian to be a commissioner, but actually an out lesbian who had written about gay rights. So that was really problematic. But literally within 2 months of being on the commission, I decided that the main impact I was going to make on the commission was because I was the first out administrative law statutory interpretation professor to be a commissioner. Because, like, I actually kept reading the statute. So what are we supposed to do? What authority do we have in our statute? So here's the thing. In 1972, protection for federal employees and applicants was added to Title VII. So in 72, they got their first protection from discrimination on, the various grounds protected by Title VII. At the same time, Congress created this administrative option that individuals could use in which EEOC would be the ultimate arbiter of whether discrimination occurred. Ultimate arbiter would actually issue decisions about whether discrimination had occurred. So this is very different from a commission decision in the private sector where we're just saying, we think there's reasonable cause to think discrimination occurred, and it triggers an obligation to try to conciliate. Nothing actually happens unless the employer agrees or a court ultimately agrees. Federal sector, we decide whether discrimination occurred or not. If we find discrimination, a lot of significant relief we can order, not just reinstatement and back pay, but damages. And an agency has no right to appeal an adverse decision by the commission to a court. Okay, so we're the end of the line. It took me a while to understand conceptually why that should be okay, but then I realized, I loved it, but really, Then I realized it's a quasi-judicial power. What Congress was doing was creating this internal grievance system, a sort of first bite at the apple before, because if a complaining party loses, he or she can go to the court, even if they lose in front of us. So the whole idea is that it was two options for them. But if the agency lost, that was it. So when I came onto the commission, I would hear people from the federal sector say that the federal sector was like the stepchild of the EEOC. And that was actually true. And I think, partly was that EEOC didn't get authority till after sort of their other work had gelled. So it sort of came in later. But I think mostly it's about numbers. Okay, so we get about 100,000 private charges a year. And we resolve about 80,000 of those each year. We have a pending inventory of 70,000 because, look, you can see that difference in terms of things. But that's a lot. So it's a lot of charges, a lot of people. In the federal sector, we deal with about 11,000 federal sector complaints per year. About 7,000 of those are hearings, people asking for hearings, 4,000 appeals where we're issuing decisions. So I just think it's a lower number. But, those decisions can be important if we're dealing with an open issue of law. So, as I say, whatever reason, the commission hadn't used this mechanism. When I came on and I was looking at issue of what does sex discrimination mean in terms of LGBT folks, well, you could resuscitate commission decisions. Okay, well, that would be a pretty big deal. Well, you could issue some guidance that says that. Well, that's sort of more of a big deal. Oh, look, you could issue a decision in a federal sector case. And that is what we did. So in 2012, in the Macy case, saying gender identity discrimination is per se sex discrimination. In 2015, in the Baldwin case, said the same thing. Sexual orientation is per se, because you know what? Sex really does have something to do with it in both of those cases. We were more systematic, and legal in our analysis, but that's really what it comes down to. And then also in 2015, in the Losardi case, saying, and it's sex discrimination if you don't allow a transgender person to use the bathroom consistent with his or her gender identity. So we did those in the federal sector. Thanks. So where are we now? Well, here's what I wrote. I see EEOC as a beacon of hope, although I would not overstate the amount of light that we might expect to see. So that's sort of how I feel about this, right? So why some hope? First, any advances that we have made cannot be taken away by just one person, like the chair. The chair has a lot of control over what gets sent around to be voted on. But the chair, on his or her own, cannot undo something the way you can in a cabinet agency, right? Secretary just rescinds some guidance. Here, a majority of the commission has to vote. And because of the staggered terms, as I said, we won't even have a Republican majority until this coming July 2017. So that's one thing. Two, I think there's a basis for bipartisanship that has been created by at least the relationship I have developed with this Republican Commissioner, Vicki Lipnick. Now, EOC was very partisan before we came on. It could be partisan again when we leave, but her term goes till 2020. My term goes till 2018. I would like to see us model what bipartisanship should look like in a Republican administration as well as a Democratic one. And here is my third. We have truth and justice on our side, okay? So we just have to keep believing and fighting. Thank you. Okay, went a little overboard because we're gonna end at 1:45, so we have time for stretches before 2 o'clock. But, yes, Nina.
I just have a couple quick questions. Really interesting talk. These are at the level of just very minor questions I had while listening to you. One is, why doesn't the EEOC post its guidances on regulations.gov if it really wants to get comment?
Mm-hmm.
Two is, what mechanisms does the EEOC have to make sure that agencies in their federal sector determinations actually obey?
Yes. Right, so you heard that. Number one, why don't we post our guidances on regulations.gov if we really want input? And two, how do we ensure that federal agencies comply with what we say? So, on the first, so it was a big lift inside the agency to get agreement to even post this guidance on our website for 30 days. I mean, and literally the reason it happened is because both Commissioner Lipnick and I wanted to do it. And you can understand the resistance from the civil service, you know, oh my God, you'll put it out, you'll get all of this comment, and then it'll never go out at all. Which I thought was a poor reflection on the fact that you didn't think you'd get 3 commissioners to vote for something, even if there was blowback. But, you know. But I did agree with the fact that I wasn't ready to say that the guidance really needed to go out for public input. You know, there is an OMB circular guidance about guidance that needs to go through, and, you know, we would say these guidances don't necessarily fit into that category. So I think that is the issue, you know, because, yes, we want input. I mean, the reason I pushed for it is, as I would say to my staff, look, I think we're smart, but I don't think we're that smart, you know? And so what if we write a paragraph that's just not written well, and some employee group can tell us, write this differently? Or there is some issue I haven't thought about from a business perspective. So I sort of feel the people, the organizations we want, they'll know, and they will go to our website. So that's compliance is a really huge, I mean, it says in every order, you have to comply and you have to send us a notice of what you did in terms of compliance. And you know how many people we have working in our agency to follow up on compliance? The huge number? 2. I mean, what sort of thing is that? And sometimes there is compliance. The person gets back on the job, the person gets the money, you know, they pay the damages, but I feel sometimes it never goes up to the top. The deputy secretary never knows that they just paid out $50,000 in damages on a harassment case. Well, that's a problem, because if you want to change things going forward, you want the top folks to know and things to happen. So, I mean, I have a bunch of ideas about how I think we need to talk from the commission level to the Dep Secretary level about stuff, and the moment there's still just ideas. But, yeah.
So I also have a few, kind of ad law-esque questions. But so one is, you mentioned that the regulations do have to go through a RIA. So I'm just curious about what the basis for that requirement is. And then just a couple in terms of consultation or input. So prior to the guidance being on the website, was it really the case that you didn't get comment, or you just didn't have a mechanism for getting broader comments? Because a lot of what you hear about agencies generally is those who are in the know or connected will find a way to get their views heard. So one of the reasons to publicize guidance is actually to level the playing field somewhat so that that bias isn't necessarily there. And then what about other agencies? So how do you interact with other agencies in the same space and leverage those interactions?
Yeah. So great question. So number one, on the first, many independent agencies, they don't have to send their regulations to OIRA. It's like a big piece of being an independent agency. The Office of Legal Counsel at Department of Justice in 1978 and then again in early 1980s ruled, I think somewhat for political purposes, that EOC was not an independent agency. I really don't know if that analysis would hold up now. I mean, because the first analysis was, we don't do quasi-legislative or quasi-judicial work, which you could say we didn't do in 1977, 78, although even there, but certainly couldn't say now. But there's just been that remnant of that, and so we've just always had our regulations go. Again, you know, we didn't, ADA, we have substantive rulemaking power, GINA so we've just, I think, done more classic regulations. And I have to say, you know, I was just reading the Kidra Revez article about independent agencies, and, you know, I think there is some utility, actually, to having to go through OIRA, even as an independent agency, because there is some utility to getting those other agency reactions. So it can be annoying and problematic and, again, political, but so that's why, and that's just never been challenged. Guidance, my sense is there was like no input. And here's why. Again, this was a little bit of a seismic shift for the agency when I came on, because what used to happen is the Office of Legal Counsel would write these guidances and then send them up to the commission, and there'd be what's called a briefing period. And you know, often they were just 3-2 votes. Like whoever, the head of the Office of Legal Counsel was picked by the chair, Republican or Democratic, and there wasn't a lot of negotiation, changing, and I don't really think the OLC folks reached out to them. You know, they were just updating the compliance manual, in a sense. You know, when I came on, I just felt like, okay, I really want to hear what the OLC people put as what I saw as a first draft. And then it moved to us. And so the first one, which was on criminal background checks, he ended up having just like 6 weeks to work on it. And Vicki Lipnick and I held about 5 meetings with people, you know, on both sides, because we wanted to know. I didn't get a sense that had ever happened before, you know. So yeah, so I think that's a pretty big shift. The third thing, in terms of working with other agencies, I think the flip of us being part of the OIRA system is we get their regulations as well. I'd like to see more of us sharing our guidances with them, which there isn't as much of a structure, although now that we're putting it on the public website, it's a little bit easier.
So you mentioned how much interpersonal relationships play into how the EEOC functions, and I contrast your description of your bipartisan relationship with Vicki with how the FEC operates, an agency I know a little bit more about. I'm wondering, do you see that relationship, anticipate that relationship evolving as the commission shifts from Democratic hands to Republican hands? Do you see, was your relationship built on the knowledge that you had more leverage than she did over the last 6 years? And do you anticipate that changing? And another dynamic with respect to the EEOC, do you think, and you probably don't have the counterfactual, that the agency operates differently perhaps because of its mostly female composition right now?
Yeah, so that's really interesting. Number one, so the EEOC always had like one, you know, female commissioner, and when I came on, there were 4 women, 1 man, Stuart Ishimaru, and then once he left, we have always been 5 women, which I think is fantastic. Now, the problem, of course, is, given Sunshine Act, it's not like we can all get in a room together and be collaborative and, you know, but, I mean, I don't, like, there was one Republican commissioner who did not get confirmed for a second term in this last Congress, a woman, but she never really was, she was very good at voting no, which she did, but I don't think it really made a difference, so, that's like a gender essentialist question generally, right? So, but I think in terms of interpersonal relationships, I think there's two things. I think there's a history of a commission often being partisan or not partisan. So I've talked to folks at the FTC who feel like there's been more of a history of bipartisanship, but that can get ruined if you have someone coming on who is not like that, right? Or you can have an agency like the EOC was definitely very partisan for at least the 10, 15 years before we came on, and then like this happenstance of two people coming on, one Democratic commissioner, one Republican, who shared this vision of governance, and I think we've shifted the dynamic, but like I said, we shifted the dynamic and we created some structures, like the strategic enforcement plan that we now voted on has enforcement priorities. A new chair can't just stop those. You'd have to get a majority of the commission to vote. So I think even when we leave, maybe there'll be some structures in place. And in terms of going forward, I mean, part of why I believe that even though I'm now in the minority, and so because that other Republican commissioner wasn't confirmed, it's only Vicki who's there as the Republican. So she's the acting chair, and they couldn't choose anyone else as acting chair because she was the only one standing. So we have 3 Democrats and Vicki. And like I said, that'll shift. But, when I first came on, and here's a good example, the GINA regulation, what we got from the staff at our Office of Legal Counsel had a particular provision that was very pro-employee, but it was really dramatic in terms of what it would have meant for employers, a real restriction. And I looked at it, and I just didn't think that, so the 2 Republicans were ballistic. I looked at it, and I just didn't really think that that's what the statute required. And so I said I wasn't voting for it unless that got modified. And so I think that was and then this has happened over time with stuff. And many times she and I just vote differently, but I think she has seen the integrity I've had in terms of voting in certain ways. I've seen her integrity in terms of voting, not just what the political winds would say. She voted for that criminal background check guidance after she and I negotiated some pieces. So I'm just hoping, in terms of the trust that has been developed, the actions that have demonstrated the trust. But I will tell you, if the 2 Republicans that ultimately come on after July are much more to the right of her, who don't have that same commitment, she's going to get pushed from the right. You know what I mean? To not be co-opted, right? Be with the program. So this is all stuff we're going to have to see. Okay. Oh, do we want to do one last one? Because you organized this symposium, so you have to. So.
Litigation and what do you think might happen?
Such an interesting thing. So, so HB 2 that affirmatively mandated discrimination against transgender folks by saying you will have to use the bathroom consistent with the gender on your birth certificate. What that generated was these various lawsuits, right? Affirmative lawsuits by the ACLU that's valid under either statute, constitution. A lawsuit from the state of Texas and others against Department of Education and us and others saying you overstepped your bounds through, you did not follow APA procedures. Which, by the way, the other thing in terms of federal sector, we do have the right to issue substantive regulations under our federal sector work, and our federal sector opinions are clearly, from my perspective, not governed by the APA, right? They're not regulations, and they're not hearings required to be on the record. So, and all they did was challenge a fact sheet that we put out that summarized our federal sector decision. So in any event, but we got caught up in that litigation. Department of Justice is our lawyer, and the district court ruled against the government, so there's an injunction. So we cannot be doing, investigations and stuff on transgender access restroom cases. So query what's going to happen, because I think we have a different type of lawyer defending us in this case. So I'm not sure what's going to happen in terms of EEOC. You know, in terms of what happens to the law generally, as you may know, this issue is up at the Supreme Court now in a case called GG. So this was not with HB2, but a high school kid, a boy. This is the other thing people have to realize about transgender folks. A transgender woman is not half a woman, not sort of a woman. She's a woman. And women use the women's restroom. Same thing with guys. Okay, so he won in the Fourth Circuit using some of this Department of Education guidance, and it's now up at the Supreme Court. So if the Supreme, this is why I'm saying the train has left the station on some of it. If the Supreme Court actually doesn't dig the case, doesn't say improvidently granted, we're going to get some decision. Maybe we'll get a deadlock decision, but then they'll might carry it over, right? Now, they could say improvidently granted because once Department of Education rescinds its guidance, which I think we're just waiting, right? Then they might just say, most of the case is moot. So that's back. We will hear something from the courts, but hopefully not the Supreme Court yet. Now, you get your 10 minutes break, and then we're back for a 2 p.m. panel.